Hello.
The faster we can move at it tells how young we are. The slower we are, it tells how old we are.
Where's your video?
Here's my video. I got him here.
You see
I think that's
yourself?
Cox.
It's always something. You live long enough, they come up with something else. All right, this is case number 18-172265. This is 6 Mile Associates LLC versus Jones Owino. The matter is before the court on a return from circuit court based upon an appeal that was taken and an order entered on that appeal. Your appearance for the plaintiff regarding this matter, please.
Good morning, Your Honor. Aaron Cox, P69346, appearing on behalf of the plaintiff.
All right, thank you, Mr. Cox, and good morning to you. And for the defendant at this time, your appearance, please. You kind of on mute there, Mr. O'Leary.
Sorry, Judge. Can you hear me now?
Yes, sir.
Can you hear me? Okay. William O'Leary, 38461, here on behalf of Mr. Onwenu.
All right, thank you, counsel, and good morning to you as well. I am the successor judge to Judge Brew on this particular docket, and I don't know if this case predated her appearance here. I know it was a 2017 case, it looks like, at some point. But I also know that there was some dispositive order that she entered. That order was appealed, and the circuit court overturned her order in this matter and reinstated the previous order. And I believe that that previous order was, in fact, dispositive in terms of entry of a judgment. Update me, if you will, Mr. Cox, please.
Judge, I think that's an accurate statement of where we're at today, is that the rulings by Judge Brew did reset this matter to the status of we have a default judgment as to Mr. Onwenu, but the circuit court remanded it back to this court for the purposes of essentially reevaluating the motion to set aside that default judgment that was filed by Mr. O'Leary on behalf of Mr. Onwenu, specifically with respect to whether or not good cause was shown under MCR 2.603 D1. So I think for purposes of where we're at and what we need from the court at this point is essentially that determination, whether or not the motion that was filed evidenced good cause.
All right, and so I've read the order from the circuit court. I've also read the plaintiff's motion for entry of order after appeal and for release of bond. So it seems to me that that having read that Judge Brew's decision that has been overturned was not only to set aside the default that was entered, but also to dismiss the claim, or to dismiss the claim, and so that was reset by the circuit court. So matters back before the court on the issue of whether there's good cause for the setting aside of the default judgment. And Mr. Cox, if you will, on what basis was the judgment entered by default in the matter, sir?
Your Honor, Mr. Onwenu was personally served with the summons and the complaint in this matter and did not file an answer. So the issue that we have here is the motion to set aside the default's reliance on good cause was Mr. Onwenu's mere denials of service. We briefly addressed this in the circuit court. Essentially that mere denial is insufficient. It's Mr. Onwenu's burden to demonstrate that he was not served, and simply, the self-serving refusal of the perfection of that service was insufficient. It would be my opinion, and I'm happy to further brief the court as necessary, that this court's determination is simple. Mr. Onwenu merely saying I didn't get served is insufficient and does not rise to the level of a good cause warranting the setting aside of a default.
All right, and Mr. O'Leary, given the constraints placed upon the court in terms of its remanding this matter, that the court consider the matter whether or not there is good cause for setting aside the default judgment and not to address the issue of whether there's a meritorious defense, but simply the issue of good cause, and that is set forth in the order from the circuit court, the order of remand. And counsel for the plaintiff seems to say that issue of good cause has been narrowed by the parties based on previous arguments to the issue of whether or not there is a basis for showing non-service in this matter. Mr. O'Leary.
Yes, Your Honor. What Mr. Cox has given us is a review of his arguments the first time around. What the circuit court said upon looking at the facts of this case was that it would be remanded to the court for further consideration by Judge Brew to determine the factual basis for her ruling. Unfortunately, and I fault no one, we haven't seen that, and we're still kind of stuck in limbo. According to the order of the Court of Appeals, that Judge Brew is to look into this matter further. So what I did was get a copy of the entry of orders to see if I could find a date. There was also some confusion. I did not come into this case until after, as it seems to me, Judge Brew made that decision. And I am looking through my notes here, but Judge Brew stated that using the court's discretion, she found a basis to show that Mr. Onwenu had a meritorious claim. That's what I would like to determine. I have a copy of the court record. I shouldn't not say the record of court. I've been trying to get a copy of the actual court hearing. What I do have is the list of all the hearings that the court had. And that seems to be the one that would suggest why she thought what she thought and what the basis of her thinking was. And I have asked the court for a copy of that. And you know better than I do how busy the clerks are. And I haven't received one yet. That's what I'm waiting for.
All right, I do see in the file, of course, the court inherits this matter, which is okay. I do see that there is a transcript, and the title on that transcript is motion to set aside the default hearing before the Honorable Judge Brew. That was September 16, 2019. So that document is in fact available. I guess I'm looking at the constraints imposed by the order of remand by the Honorable Annette Berry in her order dated the 10th of August of 2020. That order provides in the final paragraph, it is further ordered that the matter is remanded to the lower court to specifically engage in analysis of good cause under MCR 2.603D1. So, you know, she does not invite this court to look at the issue of meritorious defense because obviously we can't get past the issue of good cause for failure to respond to the complaint in a timely fashion. In addressing the issue of meritorious defense is of no moment. So she specifically remands the order with that specific invitation that this court look at good cause. And I guess I'll grant a brief adjournment if the parties need to address this issue further. But it sounds like to me that a complaint was filed the time the plaintiff alleges that the complaint was served, that there was notice given by virtue of that service, and that the time to answer expired, and no answer was made. And when no answer was made, the plaintiff petitioned for entry of judgment by default. And so we're left with the question, upon the filing of a motion to set that default aside, the question becomes, is there a showing of good cause as required under MCR 2.603D1?
And Your Honor, it is my belief that there is a record in which Judge Brew stated her good cause. I don't have that. I was brought into the case for the following hearing, and I was not in attendance where Judge Brew said, the court finds within its discretion that there is a good cause showing. I need to see that record. I would very much like to see the record, because then we have something that tells us what she was thinking and why, but right now we don't. And the point of the judge's decision at the time of appeal was to get a sense of Judge Brew's thinking and the basis for her decision. We don't have that yet.
But she had the transcript, did she not, Mr. Cox?
Judge, I don't know that she has the transcript that we are talking about. We have a registration of actions, and I have been trying to get a copy of the transcript. As I say, I haven't got it yet, and I blame no one for that, but the busyness of the court's clerks. But I want to see that transcript as well. There's something there, and it should be heard.
Thank you, counsel. Mr. Cox?
Thank you, Your Honor. Judge, maybe Mr. O'Leary has simply forgotten due to the age of this file, but
excuse me, Your Honor. Whenever we're here, he always says, I've forgotten something or I've gotten something wrong, and I'm tired of it.
So, Larry, I'll come back to you. I'll give you a chance to
Judge.
talk.
I apologize.
Thank you, Mr. Cox.
And to counsel.
Thank you, Judge. I was just suggesting that maybe he forgot because of the age of the file. The transcripts are a part of the appellate record. Those transcripts were attached to all of the briefing and in the circuit court. They were served on Mr. O'Leary. Mr. O'Leary was in fact listed as the attorney of record on the transcripts appearing at the hearings. So he certainly should have them in his file. And if he doesn't, I'd be happy to email them to him again. But his statement that he wants to see some other record related to this case, I don't understand, because there is no other record other than what he's already been provided.
Judge, that is incorrect. And this is an argument Mr. Cox has made before. I was present after I became the substitute attorney on the case. Before I became substitute attorney on the case, there was a hearing held by Judge Brew on the issue of whether or not there was a basis to determine Mr. Onwenu had not been properly served. Based on that hearing, she said, no, he wasn't properly served. And then she gave the parties a chance to rebrief what they said. But I've never seen a copy of that. I don't know why Mr. Cox can't see. I'm not a part of the case in the motion hearing before I came in. And then we had two hearings on the issue of whether or not there was a legal basis for Mr. Onwenu to argue, that he needed relief. And both were argued extensively, and Mr. Cox did not argue them. He was not part of that argument. And the judge ruled both times. Says, no, we're going to set this aside, and then allowed us a second argument on it. She said the same thing. But Mr. Cox, when he asserts there is nothing other than those, and he didn't send me those, but nobody has sent me the argument before I got in, and that's what I want to see. And I think Mr. Onwenu has a right for me to see that.
All right. Well, I know that just looking at the file that I have in front of me, I know that a record went up to the circuit court, the appellate court in this case, and that record, of course, it shows in my review of that record dated the 16th of September 2019. that Mr. Jan Rubenstein argued for the plaintiff, and Mr. O'Leary argued on that date for the defendant. That record was produced and sent to the circuit court as a part of the appeal in an effort to set aside the determination of the district court. So it's two things that come to mind. One is how reliant, what reliance does this court have, or requirement does this court have to rely upon the determination of Judge Brew, and whether or not the court should hear this matter in the first instance on the issue of good cause, because the appellate court had that issue before them. I guess they felt that they felt that Judge Brew did not address that issue, and so the court sent the case back for a specific determination on the issue of whether or not there's a showing of good cause. And so I'm the judge on this matter now, and if the parties want to offer information regarding whether or not there's a showing of good cause, I'll make that determination in this matter.
Your Honor, if I might, David Palmieri argued the issue in front of Judge Brew before it came to me, and I made the record that counsel forwarded to me. David Palmieri's arguments have not been entered as part of this record. They're not there. And that's what I'm trying to get a hold of.
Yeah, and I don't see a record produced other than the September 16th record. It seems like the September 16th record is the record upon which Judge Brew made her ruling. And that is the record that went to that's the record that went to the circuit court.
Your Honor, I'm the attorney on the September 16th record.
Yes.
Before that, David Palmieri argued the case, and that was the case, that was the argument during which Judge Brew said there is a basis to set aside these matters and to give Mr. Onwenu relief. She said that, but I don't see a copy of that, and that is not part of the record. And for Mr. Onwenu to be further denied the chance to make an argument when it's never been presented, I think it is fundamentally unfair to him. And I don't criticize you, Judge, and I don't criticize Mr. Cox.
Not a problem, Mr. O'Leary. Mr. O'Leary, I think that you drive to the particular point here. The circuit court sent it back saying that the court has to specifically address the issue of whether there's good cause. So when do you want to argue that? When do you want to present evidence or whatever on that issue? Because that's the only issue that remains as to why this matter was remanded to the court. And whether somebody argued that before or not, that court did not have anything to go on. I will make a record. You can present whatever you wish to present to show that tends to show that there is good cause as to why the default should be set aside. And so we need a hearing on that. I thought that perhaps the parties were joined as to what their positions were in that regard, and the court can make a decision today. But if you need some time on this and gather any documents you want to gather, but the point is that is an issue that it seems to me that this court will hear a first instance. And if there was good cause, then there was good cause. If there's something to show that, there's something to show that. If there's not, that's not going to change. That's not going to change in the future. If good cause did not exist, then it didn't. If it did, it did. Somebody's just got to show me where that, which direction that arrow is pointing in, because the circuit court was not able to, from the record presented to the circuit court was not able to conclude any basis for a finding of good cause.
Thank you, Your Honor. I have sent a request to the clerks asking for a copy of that transcript. They have not got back to me. And again, I understand why. I will continue to press them for that, review it, send a copy to Mr. Cox, and if it's insufficient, it's insufficient. if there's a basis for saying it, then there's a basis for saying it. And I think we've met our burden.
Well, I don't think that you are reliant upon that record, and I don't want to delay this case with what some other lawyer may have said at some other time. Either your client has something to present, or you have something to present that tends to show good cause, or you don't. I mean, you can have let's call it a de novo hearing. If you have something to present, if your client has something to present, you have the right to have a hearing on that issue. The circuit court preserved that.
Well, Your Honor, if I may, I disagree with the court's conclusion there just a little bit, as this is a closed file on remand. I don't think that the defendant has the opportunity to present new evidence. I think that the court has to make a determination on the record, excuse me, on the record before it. And that's really the kind of the crux of what the issue is. The motion to set aside the default that was filed by the defendant merely asserts that they were not served. And I do agree with this court that the only determination that needs to be made here is whether or not that motion, and whatever argument Mr. O'Leary wants to provide in support of that motion, constitutes good cause for setting aside the default. I'm prepared to argue that today because it's plain on its face that it does not. As I've already pointed out, the mere allegation that I was not served is insufficient. Gary versus Morley Brothers is the Michigan Supreme Court case going back to 1926.
Let me stop you for a moment. I think it's a well-established law that the mere allegation that, well, I didn't answer because I wasn't served is not going to be enough. That's for sure. But the specific provisions of the order of Judge Berry says that the matter be remanded to the lower court to specifically engage in analysis of good cause. If I use plain everyday English to try and understand what that means, it seems that what the judge is saying is, I'm sending this back to the district court to engage in an analysis of good cause. She does not limit what this court can look at to engage in that analysis. Listen, if the two of you, wise counsel regarding this matter, say that you want this court to depend upon the record that has already been generated, and you stipulate that that is those are the boundary lines for a determination here, then the court will read whatever has previously been offered and make a decision on whatever has previously been offered on this record.
That sounds to me like what we're both asking for, Your Honor. Mr. O'Leary is saying, look at the record and the entire record, and that's all I'm saying as well.
No, Your Honor, I'm saying, excuse me, Your Honor, I'm saying the record is incomplete, and that's the problem. Without that previous motion, when the judge first said, yes, we can set this aside, I accept Mr. Nwenyu's arguments. Without seeing what she was thinking and why she said that, we have an incomplete record. All I want to do is get a copy of that and review it.
Right,
Mr. Cox will get a copy, and then we can say, yeah, look, you're right, I'm wrong. You're wrong, I'm right.
The two of you are on the same page, and that makes a lot of sense to me. Now, the circuit court order seemed to broaden the boundaries, but the two of you are on the same page that there is some additional record that should apply with respect to the transcript of September 16, 2019. So we just need to find out what that earlier date was, and someone ordered the transcript from the court reporter that was reporting on that date. Let me see if I can make that simple. If there is a reference in the transcript that we do have. In the transcript, it says this case was initially, I'm looking at page 5, case was initially filed, the small claims, the case was dismissed on May 24th. All right, that doesn't do anything. I'm seeing if there's some history that will give me the date. All right, I see on July 31st, 2019, defendant filed a motion for entry of satisfaction of judgment. That really doesn't help. So let's go a little further. So judgment entry was on July 27th. 2017. Let's see what else happened. I'm looking for dates in the transcript. Just right. So I've gone through the first 12 or 13 pages of the transcript, and I'm seeing issues about a judgment being entered, satisfaction being filed, and dates in reference to the same. But I'm not seeing any reference to a previous date upon which there was a hearing on the motion to set aside the default judgment. So if someone has what that date was, let's look at the register of action. Anybody looked at the register of action, be able to
Your
determine
Honor,
that
I
date?
apologize. I have it. I had what was a likely date where Judge Brew says, I find a basis. And if we can get a copy of that, we can figure out what.
Okay, I think you stay somewhere near your microphone, Mr. O'Leary.
I'm sorry, Judge. I had the register of actions. And shortly before I came on to the case in September, Judge Brew had a hearing in which she said, I find a basis for ruling in Mr. Onwenu's favor. And then we had two following hearings, which we've discussed. We argued those with Mr. Jan Rosenberg. And the judge concluded, as she has concluded earlier, I had that paper in front of me, and now I don't seem to have that paper in front of me. But I believe it occurred in August, where there's reference made to her decision and why. And I just want to see the actual transcript. And I can go through my
All right, if
papers
you
again,
can get-
find it, send the information to you and to Mr. Cox, and request the transcript again.
Judge, I am looking at the register of actions. There was a court appearance on July 15, 2019. The register of action states, motion to set aside default judgment adjourned, court's discretion. Motion to set aside default judgment scheduled 9/16/19. So I don't know if that's what Mr. O'Leary is referencing, but that's the only other associated hearing that I can find. Mr. Onwenu's motion to set aside the default was filed on June 13th. The response was filed on July 8th. So I can't see how a hearing would have been held prior to that relative to this issue.
All right. Well, that gets us closer to where we need to be, and that's, I think we need to determine whether there's a transcript from that July date.
Your Honor, she did allow further argument. She says, if you want to come in, and she gave Mr. Rubenstein 2 bites of the apple after that, so he could make a clear record for himself. But
Right.
she made a finding at the previous one. And Mr. Cox has told us that was in July, I think.
All right, so somebody needs to file a request for that transcript, and we'll find out who the reporter was. Okay, so that's
Very good.
easy to do. All right. So just submit that, and I was looking at the register of action to see if there was any indication of who the court reporter was, but we'll have to find that out.
There
and get
isn't,
that.
Judge, but they've told me I can contact whoever's in charge of the court reporting, and they'll get it to me.
Right.
And I'll
exactly.
jump on that right away.
Yes, sir. Yes, sir. And the person over the court reporters What's her name?
Ms. Triplett.
Miss Triplett.
Yeah.
Is the person who is over the court reporting services. All right. So I'll go ahead and set a new date. I didn't want this to linger too long. I know that with the order of the circuit court, that this court would be duty bound under that order to reinstate this case, setting aside the order of dismissal and bringing this case back to, if you will, the status quo, and that is that there was a judgment entered. That judgment remains in effect at this time, pending a decision on the motion as to whether or not the judgment should be set aside. So what the circuit court did was the circuit court reset the matter, established that there is that the case is reinstated, that the judgment is reinstated, but that the motion is yet pending because this court has to make a decision on whether or not good cause exists for setting aside the judgment. So I'll sign an order consistent therewith, and I suppose that on that judgment that the court should stay execution pending the outcome of the hearing on the motion to set aside the default.
I have no problem with that, Your Honor.
All right.
Thank you, Your Honor.
I'll sign an order consistent with the same.
I have a
Thank you.
question.
Are you on this case?
Yes, this is my case. I'm Erica Van Hook. They sent me the wrong letter as far as what the Zoom account was. So I just called 36 District Court and then they gave me the right because they just made changes.
So you're on the 6 Mile versus Jones-Onoe case?
Oh, no. They're
Well,
giving
stop
me,
interrupting my hearing. Wait, I'll come to you in a moment. All right. So do you understand the nature of the order, Mr. Cox, that I suppose you'll be submitting? You understand the court's order in this regard?
I apologize, Your Honor. I didn't understand you wanted me to submit the order, so I'd ask politely if the court could reply. We're entering an order consistent with the circuit court's order and setting the matter for a pretrial date.
We're setting it for a hearing on the motion to set aside default. The order provides that the case is reinstated, that the judgment is reinstated. This court determines that the execution of the judgment will be stayed until the completion of the hearing on the issue of whether or not there is good cause for setting aside the default. The court accordingly sets a new date for hearing in this matter. And that date of hearing, I'm going to go ahead and set that out for the 24th, actually the 28th of June. I know that that's I hate to put it out that far, but I realize that a transcript may need to be produced. And so I'm hopeful that the transcript will be available in time for that hearing date. That is on a Monday, June 28th, and that will be at 10 o'clock a.m.
Your Honor, is the court also permitting the parties to file any supplemental briefing?
Well, no, not at this point. It seems to me that the dispositive issue here is the combination of the transcripts previously submitted and then this court's exercise of wisdom and prudence as to whether or not that record shows good cause. And it seems that the circuit court has left that decision to this court. Now, certainly, if the parties on that record wish to offer legal arguments regarding whether or not the set of facts justify a finding of good cause, you certainly have the right to do that. But
Understood, Your Honor.
It seems that there is a restriction on whether or not this court can hear the matter de novo on the issue of good cause. That good cause will have to be established by the record already presented. Otherwise, there would not be good cause. So that's what it says. But obviously, if you have a legal argument that says that assuming these facts to be 100% true, that the law says this, then certainly you can present that.
Understood, Your Honor. Thank you very much, and I will submit an order under the 7-day rule.
All right, thank you, Mr. O'Leary, and good day to both of you. I'll see you on the next action date of the 28th of June.
Thank you, Judge.
Thank you for your patience, Judge.
Not a problem. It's been a long journey for you guys.
Okay, next out.
All right, thank you.
This is a pre-trial
It's that motion hearing.
motion hearing. Okay.
Yes. All right, this is case number 21566864. This is Credit Corporation Solutions Incorporated versus Erica D. Van Hook and other occupants. Right, that this is before the court in regard to a notice of lien that was previously filed in this matter. Also, today appears to be a date set by the judge for a hearing on a motion to set aside a default judgment. The record should reflect in this matter that the judgment in this case was entered by default on the 14th of October 2020. And that judgment was entered for the amount of $1,405.86. Looks like there was just one moment, I'm going through the file here. I do see the brief, I do see the objections to the motion, plaintiff's answer to the defendant's motion to set aside the default judgment. I don't see the motion itself, and I see the brief in support of the objections. All right, your appearance for the record for the plaintiff.
Judge, may it please the court, I'm attorney Richard Rusin. For the record, my name is spelled R-O-O-S as in Sam, E-N as in Nancy Rusin, and my bar number is 35222.
All right, thank you, Mr. Rusin. Your appearance or your name for the record, Madam Counsel. You're an attorney, ma'am?
No, I'm
See what you're interrupting me. All right, what's your name?
I'm so sorry. My name is Erica Van Hook.
All right, thank you, Miss Van Hook. All right, ma'am. So it looks like you filed a motion to set aside the default that was entered in this matter, and of course, subsequent to it being entered, there was also a notice of judgment lien that was filed in this matter. What's your basis for asking that the court set this aside? It's been a little while ago, for one thing, and then secondly, overall, what's your basis for indicating that the judgment should be set aside, ma'am?
I just don't want this on my record. I have in full paid the balance that I own because they garnished my checks for it. So the last check that was on the 6th, I paid the debt in full, but they told me that they served me. And because I did not come to court, I wasn't able to state my case. I was never served. When they did send me the notice of them serving me, they said that they served a young lady that was 5'6", 168 pounds, and with dark black hair. And they told me that they served an address 17573 Coyle Street, Detroit, Michigan, 482. I have not lived at that address in 2 years. And when they said that they served me, I had been currently living at the Lakes apartment in Southfield, Michigan, which I had my lease to show that I had been living at that address, and they told me that that did not matter and that they did serve me.
All right, ma'am. So why did you wait so long before filing the motion in this matter?
As soon as they sent me as soon as my employer notified me that they were garnishing my checks, I filed the motion right away. I was not aware that I even had to appear at court. I didn't know about the balance till my employer let me know about it. So I'm not saying that, I didn't have the balance. I just would have liked to come to court to state my case and be some type of payment plan opposed to them garnishing checks, because now I have that on my record that I had a garnishment, and I was never able to even come to court to even state my case.
All right, ma'am. Mr. Rosen?
Judge, a couple of things. First off, like the court, I don't have a copy of defendant's motion to set aside default judgment. To be honest with you, the only reason I know today to be on your docket is based on the March 25, 2021 order that Judge Brew issued that first notified me that there was a pending motion at all that was going to be argued today. So I don't know per se what the defenses are. I understand from the testimony that Ms. Van Hook made about her place of service. But I must tell you, Judge, and to Ms. Van Hook, that I'm looking at about a half inch worth of statements from the bank that this is an assigned debt. This is the original creditor was called Synchrony Bank. They had a credit card for care credit. The care credit is found in doctors and dentists and veterinarian's office because of when Obamacare came into play in 2010. This bank went out into the medical and dental field to allow people to pay by a credit card their copay for the dental or medical services that they couldn't pay for. Now, I noticed that as I flip through these credit card statements, the defendant at one time went to Sears Dental in Royal Oak, Michigan for some dental work. She was at one time living at Coyle Street. The credit card statements that I'm looking at before charge off for non-payment is dated in 2018, which would seem to conform with the address on Coyle Street, 17523 Coyle Street, that is on the register of actions. So, and by the way, the statement I'm looking at, there was apparently a visit to the dentist office at Sears Dental in Royal Oak and March 6th of 2018. I don't know what kind of dental work was there, but there was a charge of $940. I also saw
Mr. Rosen,
Yeah.
Mr. Rosen, let me stop you for a moment, sir. It seems to me, if I'm understanding the arguments adequately, that Ms. Van Hook is saying that she's not, for purposes of her motion, disputing the issue of whether or not there may have been some indebtedness. She's disputing the issue of service. But significantly, she's indicated that that the debt has now been satisfied or paid in full.
That's true.
All right. So I guess the issue here is that if I found that there was a good cause, I would not ultimately be able to find that there was a meritorious defense because she's really acceding to the amount, the fact that there was a debt. Here's the issue I'm getting at. In light of the fact that the judgment amount has been satisfied, there's no longer any interest in pursuit here. Is there any reason why there might not be a sufficient basis to stipulate to setting the judgment aside in this matter and dismissing this case based upon the fact that that the objectives have been achieved here?
Well, may I speak, Judge?
Yeah, go ahead, Mr. Rosen.
Okay, just so I understand the record, it is true that by virtue of garnishment after judgment, all of her dental services, the judgment's paid in full. The plaintiff and the assigned creditor are not interested in a judgment against Ms. Van Hook per se. They were only interested in getting paid, which is why they came to civil court in the first place. So if I understand the record, just so that we can craft the appropriate order at the close of this hearing, I'm prepared to stipulate that, A, based on the garnishment, which has satisfied the judgment, 2, based on the record of the case, 3, that I would stipulate to, I don't know, I'll be happy to just file the satisfaction first and then have the judgment set aside, because I think that will accomplish everything. And the final thing is that the plaintiff has agreed to accept the garnishment monies as payment on whole, because frankly, Judge, as the alternative, if alternatively at the close of this record, you found that the motion should be denied, I would tell you that I'm prepared to file immediately a satisfaction of judgment, because again, the purpose of coming to court by the plaintiff has now been satisfied.
So, Ms. Van Hook, I mean, I should say the plaintiff has reached its objectives. That is that they wanted to collect money. Money's been collected. You're entitled to a satisfaction of judgment. I know that based upon the arguments that you made, that you're asking the court to fashion a way that the judgment can be set aside and the case dismissed. And so, in between those two bridges that are here, or those two boundaries, I'm trying to build a bridge, and that bridge would be a stipulation that would result in the case being dismissed. As a part of that, it would be you would have to stipulate that the actions to collect the funds and the collection of the funds were something that's okay with you. In other words, they got their money. You're not interested in objecting to the garnishment or anything that they use to get the money. They agree that they're paid off. You agree that you paid them, and based on wait, let me finish. And based upon that, you then stipulate to the case being dismissed. You get a satisfaction, and the case is dismissed. The hesitation sometimes with the case being dismissed is that if someone tries to challenge the funds that were collected to try to get the funds back, they can say, well, my case got dismissed, and so give me my money back. That is an undesired result, and particularly based upon you telling me that there was some debt that was owed. It sounds to me that to achieve the objective that you came here to achieve today, that walking away with a case that is dismissed with an agreement that the payments made are accepted, and that you agree that the judgment is satisfied, and that you do not seek to try and get the money back that was paid out, that would effectively end the case, and it also crush the record of there being a judgment against you. All right, Ms. Van Hook, you understand what I'm saying, man?
Yes, I understand. I just have a question just to clarify. Now, after I had paid the debt in full, I received another notice from my employer that said that they wanted money for legal fees. So they took out more money from my check aside from the actual original debt that I had from them, which was about $538, I believe, for legal fees.
The law would likely allow that where the action was brought to court. That would likely be fees and costs would likely be attached to it after going through the court process. So just to kind of get to it, it seems to me that the number one thing here is that you paid the debt, whatever it is. The other side is satisfied with the debt being paid. You had to pay some costs and fees associated with that. The question it seems that you raised with me initially was a question of how is it that I can make sure, number one, that this doesn't happen going forward. And then number two, how do I get the best record that establishes that this whole thing was quashed? And what I've suggested to you is the best way to do that. If I had a basis to grant your motion to set the default aside, then you start at, you essentially start at ground zero, where they would be pursuing to serve a document on you so that they can get a judgment against you. And you probably, sir?
Judge, may I clarify, Richard Gruson for the record, just to clarify some of the concerns that Ms. Van Hook had. I'm looking at the record. I'm looking at the default judgment. Now, the default judgment was filed for a total amount. This is mainly for Ms. Van Hook's benefit. The judgment was for $1,405.86. Now, she may be a little confused as a layman with what I'm going to say next, but this is what it is. The cost of filing and serving the lawsuit for the plaintiff was listed on the judgment as $105.15. By law in Michigan, even though the attorney works really hard, and even though the attorney may have a very high hourly fee, the law of Michigan only allows $75 as attorney fees for the entry of default judgment. That was entered here. So the total cost on the judgment was about $180.15. Then the next thing I would like to point out to you before I rest for Ms. Van Hook is that the garnishment that brought us to the court docket today that she identified in her testimony, the garnishment on her employer at the Judson Center indicated that the interest by law on the judgment that was entered October 14th of 2020 was an additional $11.35. They also indicated that I had filed a judgment lien and had incurred $10 cost. So the total cost indicated on the second document was for $21.35. So the total costs that Ms. Van Hook is describing only amounts to, since judgment entered, only about a total amount of $221 and about 50 cents. So that's really it in a nutshell. I mean, everything that I am entitled to as a lawyer for the plaintiff is set by law, and it's not confusing. But I just wanted to indicate that to the court because I know the court's had a busy docket. But more importantly, Ms. Van Hook, because she's not a lawyer, even though Your Honor is a lawyer as well as I am. And on that, I rest.
Not a problem. Not a problem, sir. Yeah, I mean, they essentially, the court oversees the imposition of various costs and expenses that may occur as relates to a file because there are certain restrictions there. And under some contracts where parties enter into various contracts, a contract will provide for actual attorney fees. But and generally speaking, when it comes to the filing of complaints regarding debts that were not paid, there's a limitation on what the attorney fee can be by statute. That's controlled by statutes in Michigan. The plaintiff is also entitled to any costs that they incur in an effort to try to collect on the judgment. And then the third thing that happens is that Michigan allows for interest on the amount of the judgment, and that interest starts accruing, and whatever amount that is whatever amount it is. So that combination of things has resulted in whatever amount that you pay. If there was a garnish, for example, an amount, say $500, and the debt was $200, then the garnishee could only release the $200, and if they release more, then the plaintiff would be required to return the balance of any amount over the judgment amount to the defendant in this matter. So those are kind of the logistics of the judgment. It seemed to me the reason that we engaged in some of this discussion that Ms. Van Hook, you were trying to get to the best conclusion that you could in terms of how this is documented going forward. And one of the ways that concludes it on its face is simply a satisfaction of judgment. But it seems to me that a deeper way of doing this is if the parties could stipulate under certain conditions that the judgment in fact be set aside and the case be dismissed, as long as there is agreement that payments have been made, payments have been accepted, there are no further issues between the parties on these matters. The plaintiff seeks no further money, defendant's not seeking any return of money, and this becomes the end of the case. Then maybe you get the case dismissed, the judgment set aside and the case dismissed, and that's the end of this in that way as well. That makes sense to you, Ms. Van Hoek?
Yes, sir.
All right. Mr. Rosen, would you fashion an order towards that end, resolving this case, sir?
Yes, Judge, I'll be happy to do that. I'll write it and have it typed up. Unfortunately, I mean, if you want, well, excuse me if I speak familiarly, but does the court have a fax? I can fax that directly to the court if you want today, or I'll submit it by Sunday.
I like email.
Email is even better.
All right, real good. And so where you want to send it to is Latifa, Latifa CR538.Hunter at 36districtcourt.org. That is by clerk. And if you email that over, we'll get it right away. And Ms. Van Hook, if you have a